Welcome all. My name is Hans Jakob Bonnier. I'm chairman of Swedish-Polish Chamber of Commerce, and we are very happy to see you all here. Today we are going to have a seminar on mergers and acquisitions. Well, there are a few things that can be said about mergers and acquisitions. It's a good way of growing the company quick if you have the money. Of course, there are some hurdles and pitfalls that you can fall into, and perhaps we will learn something about that today. Anyway, it goes the old way of buying cheap, selling expensive. So that's a good rule to start with. Fine. Thank you very much for coming. And we are going right on to the... we have a moderator who is here. So I'll give it the scene over to you.
Thank you very much. My name is Mariusz Kowalski. I'm founder and CEO of Waterwork Partners, and I'm delighted to be your moderator today. We have a truly stellar lineup of speakers and panelists who know literally everything about M&A. So I welcome all of them. I also welcome all members of the chamber, all people here in the room, and everyone participating online. I do hope it will be a very interesting event. I encourage you to submit your questions through chat. We will continue with the presentations to start with. So then there will be time for a lot of questions during the Q&A part. But now I would like to invite the first duo of speakers, namely Anders Elgemyr and Jorge Abugaber of Carlsquare, who will tell us what makes a successful transaction.
Thank you. Do we have 2 mics? We already heard this going to be like buying cheap and selling at high price. Wasn't it like that? Very easy. So my background is I started as a telecom analyst beginning of 90s. Started with the M&As like in the 90s, started a company in Sweden called ByArb Fondkommission. We merged with a German company and we created the brand name Carlsquare 5 years ago. So we are not so well known, but we are kind of big, so we come back to that. So Jorge.
So surprise, Jorge Abugaber. I'm the Polish partner at Carlsquare. You may not have expected that. But in fact, I've lived 12 years in Poland. Mówię po polsku in case anyone would like to speak Polish with me later. I am originally American and Mexican. Grew up in Mexico, lived in the United States for about 12 years. My wife is Polish, and that's the, let's say, Polish link brought me over to Warsaw in 2012.
That's cross-border.
Cross-border, yeah. I spent 18 years in M&A, out of which 12 have been in Poland. I worked at JP Morgan, Trigon, which is a Polish investment firm, Santander Corporate and Investment Banking, and as of June 2023, I've joined Carlsquare as the partner managing the Warsaw office.
So a short introduction to Carlsquare is not taking too much time about us. We've done a lot of deals, and usually that's a bragging about what we have done and sort of not going into that too much. But it's one thing that is very interesting for everyone is like we are taking a German company from Germany and doing a Swedish IPO with it right now. And it seems that the IPO window is opening up. So we have had like 40 investor meetings the last weeks, and people are interested to buy into the IPO market again. That's good news.
Also, maybe one interesting thing is both of us have done, it's a bit unusual for M&A, we've also both done ECM. And
ECM is like equity capital market, yeah. So it's like doing the fundraising and doing IPOs.
Exactly. So Anders, of course, focused on more on the Stockholm market, the stock exchange here. I've been advising on the Warsaw Stock Exchange, IPOs, SPOs, and other such transactions.
And here is the team in Stockholm and the team in Poland.
So as of about 4 or 5 months ago, we were a team of 1, then 2, and now we're up to 5 people pictured, and we will be a team of 7 in the next month or so. So we're growing quickly in Warsaw.
And this is a paleo of what we are doing in Carlsquare. So we are globally today. So we have offices in 8 countries. We have in 8 countries in 11 cities, very dominantly in Germany, where we have 4 offices, and now 1 in Poland, and 1 in San Francisco. That's the last one. So we are relevant in all kind of transactions. So what we do, we are mostly helping entrepreneurs to sell companies to some buyers. It can be whatever buyer. It can be a fund, it can be another company, or it can be like an IPO. So it's different ways to sell companies. So 80% of what we're doing is like sell-side mandates, and 20% we are helping someone to buy another company. I can easily have 50 to 100 mandates in Sweden going out to Germany and Poland and try to find relevant targets. It's really many Swedish companies are looking for targets in Germany and Poland right now. But I'm amazed about how few transactions it is cross-border Sweden and Poland, actually.
Mm-hmm.
So this is the league table. We are number 1 in Germany. And let's go over to the M&A process instead, I think. Do you want to take this?
Yeah, that's so surprising, honestly. When we look at how much deal volume has taken place, how many deals have taken place between Sweden and Poland, I was a bit shocked. I mean, I think the number is very low, much lower than it could be, much lower, I think, than it should be. And I think there's some reasons for that, and we'll get into it. Of course, we've seen some, let's say, growth over the past couple of years. This is a bit reflective of the global trends in M&A as well, where 2021, 2022, 2023 a bit less, yeah. But and you can see here this number, we've broken the scale, but this number should actually be much higher, and that's reflective of how the entire M&A market is looking. But I think that, you know, if you look at an average of 5, 6, 10 deals a year between countries that are so close to each other and that I think share a lot of values, I think it's too low. Yeah.
And I think that the relevant cross-border is Germany, Poland, isn't it? Or where do you see the most transactions coming?
Honestly, we see the similar pattern. I think that, there's many more transactions between Germany and Poland than between Sweden and Poland. But compared to the potential, or really the logic to M&A behind these 2 countries, it's I think it's too low. So I think in general, Poland is underutilized, underappreciated, and it's something that, partly we'd like to change as Carlsquare. And part of my role is bringing attention of our global clients, or our clients from Sweden or from Germany, from the US, attention into the market. Yeah.
And this is a mission for all of us here, I think. It's a very low transaction activities between the countries, and we should do something about it. So how do we get there? So I think that a little bit, so the opportunities are there, I think. What if you're talking about, if we have so many companies in Sweden that are like eager to buy companies internationally, why don't they buy in Poland? But what can they find there? Because I think that the misconception that we have, like a bias that I have, is that Poland is like construction, some engineering, and that's it, sort of. Is that correct?
It's funny, I would say, when you talk to many Polish entrepreneurs or Polish corporates, I think it's a similar misconception, right? So the large Swedish corporates that are in Poland that have been present for years have been industrial or construction. So I think it works in a way both ways. I think that's totally not the case any longer. Maybe, you know, when the regime changed, when the Berlin Wall fell, and then when Poland became, let's say, more of a democracy and free market nation, probably the first points of entry and the easiest opportunities were in those more traditional segments. So construction, industrials, manufacturing. The past 24 years have changed a lot. And what we're seeing now is Poland is becoming basically a innovation hub for all of Europe, for most of the EU, or for Europe, in fact. What we see today in a lot of our clients, software companies, IT companies, services companies, tech-enabled services, new technologies. I've done biotech transactions, I've done software transactions, IT transactions. So this is an area where Poland is really very active and has a lot of potential. I think we're seeing companies being more and more aware of that. And if you look at deals within those more innovative sectors, those are on the rise. I think it's perhaps a misconception that needs to be, you know, rectified in some of our more relevant geographies, like Sweden, for instance.
Another thing that is like pretty common, because we've been around in Poland and trying to sell Swedish companies to Polish companies, that's not working, because you are laughing at the valuations that you're asking for. Can you like enable? Talk a little bit about that, because
it's you know, I think, well, so what I heard from you, which I found interesting, is that when a Polish company wants to do an acquisition in Sweden, it's just the valuation gap is not there.
Yeah,
right? Yeah.
There are a gap.
Yeah, I mean, yeah, the valuation gap is there.
Yeah.
The valuation simply doesn't meet. Then, interestingly enough, when you ask our clients, well, okay, you don't want to buy for those multiples, but would you, in that case, would you sell for those multiples? Then suddenly it's too low, right? So
yeah. So what's wrong here?
Yeah. So I think, you know, if we think about the discussions as well, and I think some cultural elements play in, and I think that's definitely changing over time. But I've dealt with some of my clients are, you know, 30s, some of my clients are 50s, right? And I do see sometimes some differences in approach. So I think some biases, you mentioned biases earlier, that need to be dealt with in a way, or that have been a barrier to transactions. I would say older generation Polish entrepreneurs tend to be a bit distrustful, in particular of unsolicited approaches. So if you approach them with a client and say, "Hi, look, you have a great company. Would you like to discuss?" On the positive side, they are typically interested to talk. This is different than Germany, for example, where it's very difficult to get a meeting or a conversation with an entrepreneur. In Poland, they would be quite open. They would be interested. However, there is a bit of a defensive approach. So it's always, okay, someone wants to trick me or take advantage of me. It's something that I've seen. It differs a bit from the approach that let's say, our Swedish clients could have, right? Which is more, let's say, open to discuss and discuss openly. So for example, I see this in one mandate I have a German client looking to acquire Polish companies. And you can see this difference in approach in the meetings themselves, where our clients are very open, bringing in some presentation, showing a lot of information, whereas the entrepreneurs are typically a lot more reserved. And that's, I think, one gap that would need to be bridged.
So may I ask you how the Polish people or Polish entrepreneurs are looking at Swedes?
I think it's a very interesting geography, a very interesting group of potential buyers from a Polish perspective. So I would say it's definitely less historically packed than some other countries in Europe. So
you're talking about Germany now?
Some Western neighbors.
Russia?
Yeah, exactly. Poland has the unfortunate geographical location to be between two very strong historical empires. And, you know, amazingly, even though it's 2024 today, there have been some historical, I mean, there is something always in the back of the mind, especially older generations. Yeah, you know, it's never said, but I think there is a bit of maybe a bit of distrust related to that. With Sweden, of course, I think the last, I mean, of course, if you ask, I think most Poles, at least my experience about Sweden, you know, what's the first thing that comes to mind? Usually it's Potop, right? Which perhaps many know. So this invasion that took place in the 1600s.
Some years
time
ago, I would say.
Some years ago. Some years ago.
And didn't you say excuse us or something like that? But you're
Um,
still talking about it.
It's I wouldn't say it's the main topic, but I think, you know, the takeaway is, when speaking, at least my experience with Polish entrepreneurs there, and especially when you talk about cross-border M&A or buyers from other neighboring geographies, there is always some sensitivity around that topic. Now, of course, that times change, and we're seeing younger generations coming in, the new generations of entrepreneurs. Also, tech companies, IT companies, they tend to be from a different generation as well. And we're seeing that potential barrier that maybe was in place 10, 15, 20 years ago, sort of disappearing over time.
So we need to summarize, but it's more moving ahead. But we will be here, ask us question, and the reason to use an advisor is to bring overbridge the gap we're talking about, valuation, culture, things. So that's everything for us. Thank you very much.
Thank you.
Thank you very much for this presentation and discussion. It was very interesting to hear about opportunities, low-hanging fruits, but then also some misconceptions. And in a way, I think it's a very interesting and good introduction to the next presentation. So I would like to welcome Conrad Wallenrodhe, a true icon of the international M&A and corporate world, who will demystify M&A a little bit.
Hello, everyone, and welcome to my part of this seminar. I will not be talking about Linklaters, which, if any of my colleagues are watching now, so sorry, guys, I did not prepare that, but I will tell you a little bit about myself, how I ended up in Poland. And it actually began 27 years ago, when my then law firm called Logelev Lehman sent me on 3-year secondment to Warsaw. Just about, and I was due to going back to Stockholm, something happened, a merger happened, a merger between Logelev Lehman and Linklaters, what it's called now. So that merger actually had quite an impact on my life, because I was supposed to go back to Stockholm, but the law firm who sent me was no longer in presence. The new law firm have thought of me in different terms, because I speak Polish, Swedish, and English. So they were of the opinion that I do much better use in Poland than in Sweden. And here I am, 27 years later. I still do my 3-year secondment. But I didn't regret any second of it. So it was quite a ride, actually, and I wouldn't change it for a single second. I was told that when I was asked to do this part of the seminar, I was very happy, and I jumped on that because I could be talking in hours about M&A and demystifying it and so on. And then I was told that I will only have less than 15 minutes to cover that, so I was less happy. But since I accepted the challenge, so there was no turning back. Well, I try to do the best. I was also told that among our participants, there are those who are very well familiar with M&A, and nothing of what you will be hearing is will be new for you. So you can try to check your emails. Whereas the other of you who are at the beginning of your M&A venture, maybe you find something useful in this presentation for you. This catchy drawing showed how we come to that, because merger is very much like a marriage. Often marriages stay longer than mergers, but that's a different story. When it comes to M&As, it's, as already was mentioned by Mr. Bonnier, that is definitely the fastest and most efficient way to grow business. And I would actually, giving the figure we see below, 3.2 trillion US dollar. That was the combined value of M&A deals last year. That was a slow year because we were still suffering from COVID pandemic. So the figure was down by almost 30%. A trillion, if you don't know what it is, that's 1 digit and 12 zeros. So it's millions. Of course, in Swedish, we would be saying miljoner, but billions means something else in in English. So a trillion, 3.2 trillion. That's quite impressive. And as I said, it was a slow year. So there is good reason to call M&A markets the biggest second-hand market in the world, because what we are actually dealing with is something that was already owned by someone else. It is actually a biggest second-hand market. I mentioned a couple of jargon we used to use when we talk to each other, NDA, LOI, IM, POI, DD, SPA. You don't need to know that. If you have a good advisor, he will know what it is. It's mostly used because lawyers can communicate faster. Instead of saying, I need this draft of shareholders agreements or share purchase agreements. I need this SPA ASAP. So it's a very fast way of expressing yourself, and you save time. And time is money, as you know, and that is very important. Given that I only have less than 15 minutes, I won't be walking you through all the stages, but this is how I see an M&A deal. Of course, if you ask another lawyer or another advisor, they'll probably have some other points to point out. These 6 are actually the most important one. Actually, the most important one, in my opinion, is the first one. That's when the deal didn't even started, but this is preparation stage, where 2 companies or 2 businesses get together and try to find whether they are a perfect match for each other or not. And then they do the SWOT analysis, try to find if synergies will work or not. And that is, unfortunately, also that part of it is very much neglected and treated a little bit like an ugly sister of the whole fine corporate work. So it's this preparation stage is most often very much forgotten. It's when I try to ask a client, what's your driving force? What drives? What's your modus operandi? Oh, we think we need to be bigger, so we find a possible suitable target, and we're gonna approach it, and we hope for the best. Oh boy, that will not end well, because you know, you need to do some really good preparation work before you proceed to the real deal. Also, what I want to point out that if you go for this first stage of business, you meet together and the future is bright and there is no problem on the horizon, don't take your lawyer to this first meeting. Absolutely not, because a lawyer is able to kill every deal before it even started. So the first meeting is about happiness, about the future, about the prospects. You don't need a lawyer to that. Lawyers, we are trained to spot problems and find solutions. We are not about happiness and champagne and that kind of stuff. So we enter the stage in number 2 when it's time to draft a non-disclosure agreement, which is very important, especially when you are the seller, because if the deal gets aborted and you don't be bought up, then you don't want your sensitive information to get disclosed. So it's very important to have a well-drafted NDA. Letter of intent is, in my opinion, very much overrated, and in my opinion, it's not necessary to have it. Because you lose time and money discussing that and negotiating it. You can't even, it's not even enforceable. It's not binding, except for exclusivity or confidentiality. So if you not necessarily need to have a letter of intent, don't get it. Often it's written just that the board has to show something to the owners when they come back home, and should justify the whole the high amount of hotel invoices and fine restaurant and so on. So they need to produce some results of this meeting. So that's letter of intent is the main purpose. Otherwise, fulfills no visible result. Well, due diligence, it's something which is very important, but I will not go to this. Negotiations is very important as well, but that's one point of information which is important to know. When it comes to negotiations, try to avoid the top dog negotiations. You don't have the highest guy negotiating, because if something goes wrong, then you are in a locked position and there is no turning back and no moving forward. So it's have a second level guy, mid-level guy who negotiate, and there is the wise guy at home, and you call him that, you know, Mr. Boss, things went south and we need to have it resolved. Then the big guy, top dog, comes in and solves the problem, and everybody's happy again. So when you have top dogs on both sides, it's probably not going to work so well. Agreement, I will not go into this, but one important point, and I think that will be addressed by my colleague who comes after me, have a good clause to solve the problem if they, not if, but when they arrive. They will say, most 100% will occur. And that is something which is very much unknown to the public when it comes to problem solving. Most go for arbitration, and that is very good because arbitration is nothing else like a private court. You compose your own set of judges, and there is only one instance, there is no appeal, no nothing. But if you go for arbitration in Sweden, then something happens which normally you don't know about, or you're not, you don't have it in your head. Normally, in arbitration, always ends up that one party is less happy than the other, and the other party, the unhappy party, since that cannot appeal against it, it will try to trick you into settle the claim in better ways, and they may blackmailing you in, okay, I will go to the public court and go for so-called, in Swedish it's called klandertalan, which in English is translated as a invalidation on formal grounds. Since you cannot appeal against an arbitration awards, you go for klandertalan, which means that why is that dangerous? Because arbitration is totally confidential. No one else is able to see what's in the document. And as soon as the documents end up in a Swedish court, everything becomes open, available for everyone. I mean, Sweden is fantastic. We know all this, but it's also a very open country. I used to work in Moscow many years ago, and it was a standing joke among Russians that we don't need to spy on Sweden. We just pick up a phone and call and ask for information. It's a price we pay for this open country. But when it comes to negotiation, when it comes to sensitive information you have in your business, you just don't want it to be open book for everyone. Of course, there is a procedure when you can ask the court to declare documents confidential, but there is no way to have the whole file declared confidential. You need to convince the judge that this sensitive information is very sensitive, and you want to have it. Confidential. But I remember the last I represented the Polish company, and on the other side we have Russians. That was just before the war started, and of course the Russian lost in Stockholm, and they have a Swedish law firm which very quickly withdrew from representing them as soon as the war started, and they went for the public court just to blackmail us. And that was Swedish Svea hovrätt. And I used to have countless discussions with the judges why we should mark that confidential. It ended up happily that they didn't manage to find the Swedish attorney, Swedish lawyer who would be representing them, because they became like a pariah and no one wants to have any dealing with them. And so the court declared the whole trial finished, because for the formal reason that they couldn't represent themselves. And since we need to speak Swedish in Swedish courts, and they couldn't produce anyone being able to represent them. But that is very important. So if you want to have a chance to choose another arbitration, like in Poland or anywhere else, so choose that instead of Polish, because in Sweden you have this open book issue that need to deal with. One also, before I move on, I don't know if you know what is the big difference between merger and acquisition. It's the simplest way of expressing is that every merger is also an acquisition, but not every acquisition is a merger. And whether it's becoming a merger or not, sometimes it turns out during the process how this will play out and how you want to proceed. The number 6 on my list is this integration period, and that's when the implementation starts. That's probably lawyers have done their jobs and got their invoices paid, went home and to another bill, and then the life started. The transaction is over, and the life started. And this is when problems arrive normally, because if you didn't do the good work on number one, you probably won't have that happy life as you were envisaging initially in number 6. So that is something to think about. Moving on, this is the merger, and it is for good reason most often compared to a marriage, like finding your second half and live happily ever after. Unfortunately, when it comes to mergers and M&A in general terms, the statistics show that as many as between 70 and 90% of all M&A deals end up in a failure. It's not a disaster, it's not a total catastrophe, but when we talk about failure, it's that the deal didn't meet the expectations they were from the very beginning. And why was that? Because mostly people had a little bit exaggerated expectations. The business plan wasn't realistic, and they were trying to show to the board that we are much better, we can do much better than actually when actually it is possible. And so it's a little bit overthinking from the beginning, and then it turned out to be a disaster. So merger is, horizontal mergers is most popular. Horizontal when two companies from the same sector buy each other or merge with each other. Like, for example, you have two construction companies. One is semi-big, another semi-big. When they merge, they will become very big and more competitive in the market. There is also vertical mergers. That's when, for example, a construction company buys someone who produces cement, concrete, or bricks or something. And another one is less popular. That's conglomerate mergers, when there's a little bit you're buying a little bit totally not from your core business. That is another kind of merger of equals. That was a little provocative from my side, because you can see for yourself if that's going to be a happy ending to this or not. But actually, I've seen this kind of deals in real life, and I would say that this is a dream scenario for a lawyer, because this kind of deal is going to go south almost immediately, and lawyers will have a lot of work to do after that. So that is, but from a commercial point of view, that is disaster. And for the record, I have nothing to do or nothing against those on the left side or on the right side. This is just an illustration. And just to give you a couple of examples from failed mergers or deals, M&A deals. Probably what is most known in Sweden, that was the M&A where eBay was buying Skype. That didn't turn out well, absolutely not. Also, when Microsoft bought Nokia, that was about in the time when smartphones start to come into use much more, and Nokia didn't actually catch up on that. So that didn't end well. Acquisitions, briefly, when you could compare merger to a marriage, so you could compare an acquisition to buying a new house, for example. It's quite straightforward. Share deal is the simplest one you can do, and the change is happening on the top level, and probably employees wouldn't even see any difference, because it's just a new owner. And if the new owner doesn't introduce any changes into the structure, so it's business as usual. It's just a change on the owner side. Asset deals are more complicated because it's a little bit like cherry picking. But the good thing with asset deal is that you don't assume any liability, because share deal there is like all liabilities follows or actually stays where they are, because there is no change except for the owners. Asset deals are also more time consuming, but share deal can also be consumed, because you have to, instead of only thinking about the shares, you need to check the underlying asset as well, because shares have a value based on what's in the assets. The Latin expression caveat emptor translates into English, let the buyer beware. That is what in Swedish we call the undersökningsplikt, and the duty to investigate. So you have to, wherever you're buying a house or a corporation, a share in a corporation, you are obliged to do your investigation, your due diligence, because there is no coming back and claiming after that. Okay, I probably went over my time, so I move on to a last slide, and that is a key message that I want you to take home with you. And starting with the realistic business plan, that's a key word, realistic, not unrealistic, because that is very important. That when that is done from the beginning, the homework before you move on to a transaction, then it will be a happy ending to that. Otherwise, it may end up in a catastrophe. This is, I will not repeat those. Also, use only experienced advisors, because I've seen mostly on the other side of transactions that some parties went for a so-called low-cost solution, and it didn't play well in the long run. There is an American saying that good work ain't cheap, cheap work ain't good. And that is something you should remember. And it's money well invested, because if you will try to save on your advisors, it may actually backfire in the future. My last point is my favorite one, is Murphy's Law. It's not actually a legal law, but you are all familiar with that. It was an American engineer back, I think it was like 70 or 75 years ago. He was working on aerospace, in aerospace sector, and was responsible for safety issues. And he formulated this rule, which reads that anything that can go wrong will go wrong. So don't expect it that it's going to turn out well, because things don't tend to act the way you want them, because there is something inherent in them, and there is actually no way to prepare yourself for this, but there is good chance that you could mitigate the risk and at least foresee the consequences and the results. And the first mentioned SWOT analysis is one good way of approaching this. So Murphy Law will not be kind of doomed for you. Okay, so that is the last one, and I know there will be a Q&A session afterwards, so whatever is not covering here, so you're welcome to ask any questions when time comes. Thank you.
Our challenge to speak at today's event. Thank you for the presentation. It was both insightful and fun. I think we all appreciate your insights. Well, you mentioned Murphy's Law, meaning that sometimes things go south. And then we have someone who will tell us what to do when this happens. So I would like to invite Piotr Bytnerowicz, who is founding partner of ByArb, who will tell us what to do when things go wrong. Welcome.
All right. Good afternoon, ladies and gentlemen. Thank you very much for inviting me. It's always a pleasure to be here in Stockholm. As Mariusz said, my name is Piotr Bytnerowicz. I am a disputes lawyer with roughly 20 years of experience in dispute resolution. I've spent almost all of my career in international law firms, and in April last year, I've set up my independent boutique law firm specializing in dispute resolution. Quite relevantly, I think, for today's topic, the last 12 years I've spent with White & Case, mainly in Warsaw. And why it's important, it's because White & Case is a law firm that has a very strong M&A practice. So that's where I've learned about M&A by actually resolving disputes that followed after the transactions when Murphy's Law took place. And what's also probably worth mentioning, what brings me here, apart from this wonderful conference, is that I have a close family living in Sweden, so I'm always happy to accept invites to come here. So I'm here to speak about avoiding and resolving disputes in M&A. And why such a topic? Why speak about disputes rather than opportunities or fat earnout payments? That's much more pleasant. So, well, let me start with an experiment. May I please ask you to raise your hand if the first thing that you think of after closing a deal is when finally you will be able to meet the other side in court? When is that you actually just can't wait to sue someone? Okay, we have two. Anyone else? All right, so roughly from maybe 70, 80 people in the room, 2 are quite keen to have disputes, but apparently for most of us, the reason to merge or to do an acquisition is not to get into conflict. Well, why is that? Why do people not want to get into disputes? Any suggestions?
Because internal problems is not going to ensure success.
Exactly. Problems don't equal success. Anything else?
Very costly.
Exactly. It's costly and it takes time. And I think we could mention many more specific reasons, but I would risk a statement that all in all, the main reason why we don't want disputes is because disputes cause damage. So that picture shows what was left, or what rather wasn't left, of my hometown, Warsaw, after World War II. And for me, it's a very telling illustration how devastating disputes can be. And they don't only cause physical damage, but they cause all sorts of damages: economic damage, emotional damage, damage to relationship. So it's difficult to continue a business with your business partner if you spent years fighting in court. So I believe this is a good reason not to have disputes. So if we don't want to have disputes, how can we avoid them? And to answer that question, I think we should first understand what causes disputes. So why do we have disputes? Of course, each and every dispute has its own unique story. There are specific reasons for it. But based on roughly 20 years of my experience in dispute resolution, I can say that all these reasons usually fall into one of those 3 categories. So first, and Conrad already talked about it, using inexperienced advisors. So badly written contracts often lead to disputes. It's usually where they are ambiguous and the parties can't agree on what they actually mean. And it's sometimes because the lawyers didn't understand what their clients' goals are if they were inexperienced. Second, communication flaws after signing. So unclear communication leads to misunderstandings, and mismanaged misunderstandings then lead to disputes. And the third sounds a little bit like from David Fincher's movie with Morgan Freeman, Gwyneth Paltrow, and Brad Pitt, if you saw that one, Seven, about the 7 deadly sins, the second of which is greed. But believe me, this is not Hollywood fiction. I have worked on, I think, over 100 disputes, and many of them could have been avoided if it weren't for the love of money. So sometimes disputes are just started because a good deal wasn't enough. Or as Conrad mentioned in his presentation, someone didn't have realistic assumptions. They didn't have realistic plans. They've aimed for the stars, but didn't know what it takes. So now that we know what leads to disputes, it's time to address the question how to avoid them. And there are a few simple do's and don'ts, which I probably should not give away being a disputes lawyer, because I could go out of business. But I'll assume you'll forget very quickly. So here goes. Don't seek to take advantage of the other party or their mistake or lack of knowledge on their side. Because if they find out, and they usually will, they will sue you. The next one goes to communication, which was already mentioned at the previous slide. So if something happens during or particularly after the transaction that you are not pleased with, don't start by assuming by default bad faith or bad will on the other side. Don't assume that they were trying to take advantage of you, because wrong assumptions very often cause misunderstandings. So don't assume, but rather ask, investigate, and verify. And last one goes without saying, just know when it is enough. You know, as human beings, we are never satisfied. We kind of can't be, in a way. So we always want more, and when we get more, it's still not enough. So I think the trick is, it's actually to be able to say, it's enough. So these are the don'ts. Now, the do's. The first one, again, is about communication. It's about communicating clearly what you mean, where you're coming from, and making sure that the other party understands and does not need to make wrongful assumptions. Second is very simple. Just be fair, or putting it to legal terms, act in good faith. And third, product placement warning, get a good M&A lawyer. And now disclaimer, I'm not an M&A lawyer, so don't come to me, but you can speak to Conrad.
Yeah. Check is on the mail.
So everything that I have said so far was focused on how to avoid having disputes. But some disputes are inevitable, and that's probably why I am still in business, being a disputes lawyer, speaking about how to avoid disputes. So the question is, if there is this inevitable dispute, how to deal with it, how to mitigate the risk, and how to minimize the damage. And the question is, do they all need to end up in court, or do they all need to end up in arbitration that Conrad helpfully explained to you? And the answer is no, they don't. And there are many alternatives to court proceedings. And today I wanted to focus on two of them. And the first one is expert determination. So in M&A transactions, very often there is room for disagreement on various calculations. For example, parties often agree that an earn-out fee would be paid sometime later, depending on the future performance of the acquired business. And the parties then get into a dispute whether the earn-out should actually be paid, whether those whether the required level of performance was met. And this is all about how we calculate it, what assumptions we make for that calculation, and what method we use. So the solution for that problem can be expert determination. So the parties can agree in their contract that if they differ on a valuation, they will appoint an appropriate valuation expert who will resolve that issue for them. The proceedings before an expert usually take only a couple of months, maybe half a year, and they end up with a determination of the disputed valuation issue. What is important, such determination is not enforceable in the meaning you can't, go to a court bailiff and have it enforced as a court judgment, but they are contractually binding on the parties. Now, you may ask, what is it worth if it's not enforceable? And this is where the other alternative dispute resolution method comes into play, which is arbitration that Conrad already spoke about. So the party who wants to enforce the expert determination which was rendered in its favor can, broadly speaking, just go to arbitration and ask the arbitrators to put a stamp on it, I would say. And then such arbitration award affirming the expert determination can be actually enforced around the world based on the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. Now, details will differ depending on jurisdiction and how exactly you phrase it in the contract. But the general approach is that the arbitral tribunal will be bound by the expert's determination unless first the expert went beyond the scope of his or her mandate. So, for example, decided on an issue of interpretation of the contract rather than just calculation. Second, the expert's determination is manifestly wrong. And third, there is evidence of fraud. Otherwise, the arbitral tribunal should say the parties agreed for the expert to determine, the expert determined, here it is. Now, expert determination can be a very effective tool that can allow you to avoid ending up for years in courts or a few years less, but still for a while in arbitration. But it also can cause you a lot of trouble if the clause in the contract is not drafted properly. And in such case, the parties can actually get into a separate dispute over the expert determination itself or the process. So in order to avoid this, three basic rules need to be followed. So one, the scope of the issues that are to be determined by the expert need to be defined very precisely, because otherwise we are running into the risk that the expert will exceed its mandate and then the determination will not be enforceable. Two, you need to specify the place that the expert determination has in the broader dispute resolution process. So in particular, is it a precondition to arbitration? Do you need to go through that process before you can go to arbitration? Or do the parties have a choice whether to go into expert determination or not? Or to what extent the arbitral tribunal is bound by the expert's determination, because you can specify that in more detail in the contract, and so on and so forth. And three, which sometimes turns out to be a significant problem. So the process of appointing an expert has to be drafted in such a way that it will be possible to appoint an expert even if one party does not cooperate, right? So usually the parties say in the contract, okay, you give 3 candidates, I give 3 candidates, and then we do a lot or whatever. But you need to have a fallback position in the contract. What happens if they don't cooperate, if they don't do their part? And the last point I wanted to cover is why it is good to combine arbitration, expert determination with arbitration rather than state court litigation. And Conrad already mentioned a few points, so I will try to just add a few details. So arbitration is a dispute resolution method that is based on parties' consent. So one of its features is that it's neutral. State court litigation is always country specific. It's local language, local procedure, local judges. Arbitration can be tailored to the parties' needs and to the needs of the transaction by selecting applicable law, rules, language to be used in the procedure, and so on and so forth. Arbitration is also flexible, and this flexibility has allowed it to make room for expert determination. And I think this is the most important feature differentiating arbitration from state court litigation, which is that there is no such thing as international standards in terms of approaching expert determination by courts. Some courts in some countries would be very well aware of expert determination and they would honor them. But in some other countries, that would be an unknown animal and it would be impossible to predict how the courts would approach it. In arbitration, it's different. There is a fairly broad understanding of how to deal with expert determination. And last but not least, in arbitration, disputes are resolved by lawyers practicing commercial law. So lawyers who have often seen M&A in real life, hence they have a good understanding of the parties' needs and they have understanding that allows them to deal with expert determinations properly. And there is much more I could say about dispute resolution and avoidance, but I think my time has come to an end. It was indeed a challenge to do it in roughly 15 minutes or so. So if you have any questions, please speak to me during the break. Thank you very much.
Thank you very much, Piotr, for your insights, and also thank you for accepting our challenge. So now we are much better equipped to avoid disputes, and we also know that when things go wrong, you'd better call Piotr. So now it's time to come back a little bit to something we talked about at the beginning, namely Anders and Jorge, among others, talked a little bit about deal flow between Sweden and Poland. There is a lot of potential to explore. And that's why we have here Fredrik Udd, who will talk about how to take advantage of M&A opportunities in Poland. The floor is yours.
Okay, good afternoon, everybody. It's nice to see so many familiar faces here today. Nice to have a filled up room as well, and it's really great to have lots of people joining us online as well. For those of you who don't know me, my name is Fredrik Udd. I'm the founder and the managing partner of Explore Markets. We work with solutions to help companies to expand internationally. And we have a focus on Central Eastern Europe and the Nordics, but also work beyond that through our international partners. And this means that we work with, for instance, to develop market channels, supply chains. That goes both organically and through M&A. So I come a little bit from a different side. I come from the business side. I'm not an M&A guy per se. But we work with M&A as well. And since that's the topic of today, I'm gonna focus on that. I have the ambition to share some appetizers and maybe a tactical advice or two about how to take advantage of the M&A opportunities that I believe are in Poland. I'm gonna start with a somewhat bold decision maybe, or a bold statement. Poland has the best acquisition targets in Europe. And this is a way of paraphrasing many people that I talk to, many M&A experts. But I also claim this to be true. And I'm going to try to share my view on this with you today. And a couple of weeks ago, I asked my LinkedIn network what they would like me to speak about today. So what topic they would like me to focus on during today's seminar. I had three alternatives. One was different sector opportunities in Poland, some M&A do's and don'ts, and some potential deals that are out there on the market right now. And votes were casted on all three alternatives, as you can see. But the winner was sector opportunities in Poland. So the other two topics, we can talk about those at another time. But today, I'm going to focus more on some of the top M&A opportunities that I see in Poland. But first, I always take the opportunity to speak more about the opportunities in general in Poland. So why Poland at all? For some of you, this might be a bit of a recap. But it's important to see Poland as what it is. I think it's an extremely attractive market for doing business. So if you're going to remember something from today, from what I'm saying, together with all other insight and knowledge, so remember that Poland presents great opportunities for business and investment, and I think that's good to have with you. First of all, it's a large market with around 38 million inhabitants. It's a large country in a European context, and it's the clear leader in Central and Eastern Europe. It has shown a great growth and economic stability, and if you look at Europe, it outperforms all other European countries in terms of growth stability over the past 20 years. And that is due to both a strong domestic market and also some great investment potential and the growth opportunities going forward. Obviously, Poland has a great location. From a Swedish perspective, it's just across the Baltic Sea, and we have spoken about that already, that it's really close to Sweden. It's also in the heart of Europe, so it's a good location for approaching business opportunities all over Europe. Poland presents a strong human capital, and the economy is really versatile with a broad range of different opportunities. And looking into the M&A field, Poland has presented a really interesting sort of overall growth in terms of M&A transactions and volumes over the past 10 years. This is a sort of a smoothened graph over the M&A transaction volumes over the past 10 years. And sure, there are some bumps in the curve. For instance, 2016 to 2018, there were lots of investors who were concerned about the changing political landscape. During the pandemic, of course, it was a little bit of a drop as well. But overall, the trend is pointing upwards. And Poland, in a regional context in Central and Eastern Europe, it's the clear number one. So that speaks for Poland. And what makes M&A attractive in Poland then? Well, first of all, you have a large number of potential targets. I'm going to go into that a little bit more in detail. But many of these companies have great and really modern facilities, technology. Many have carried out investments in factories, in new machinery. So they have really state-of-the-art assets and facilities in Poland. Many companies are showing an outstanding growth. If you compare the growth figures for many Polish companies to companies in Western Europe, most of the time Polish companies are growing really nicely. And one reason for that is that Polish entrepreneurs are really driven. They have a strong mindset. They want to grow. They are really hungry. They want to move forward all the time. And then also, if you look in potential acquisition scenarios, normally there are really good synergies and potential in international company contexts, where Polish companies can benefit greatly from instance, strong international brands, and also utilize international sales channels when they come under the umbrella of an international company. And lastly, most often acquisitions in Poland are financially attractive as well. You have many companies, or in general, the cost level in Poland is attractive. It's very competitive. You have the growth. You have normally higher margins as well compared to peers in Western Europe. And then you have an investment field which is not as highly penetrated as in many Western European countries. So it's the competition for targets is not as strong, so you can have better valuations, as we already heard, and you can also get a better acquisition price. And looking at opportunities, one substantial, I would call it almost structural opportunity that's out there is the large number of family companies on the Polish market. There are more than 800,000 family-owned businesses in Poland, and more than half of those are likely to face succession within the next 5 years. So that's what I call the great succession. And most of these, you have to remember that most of these companies are first generation owners. So they are the founders who are moving into the first round of successions. These companies have never changed hands before. A majority of those might also not have a succession plan. I've seen, or there are many studies out there that show that maybe 90+% of companies don't have a clear succession plan for their companies, or they have successors who really don't want to lead the company into the future. And what happens then? Well, if you don't have a clear succession plan, if you have somebody who is going to step down in a while, they spend less effort on the company, and the company situation deteriorates, the results decline, etc. And that's, of course, not good for the long-term development of the company, but it might be a good opportunity for somebody who steps in, take over the company and bring it into the future. So it might be a good opportunity to take over the helm of a company. But, and this is a big but, that many of the owners who founded the companies, they really don't want to sell their companies. This is sort of the last thing that they want to do. It's their baby that they are going to get rid of in some way. And it's not a dream scenario to sell off their company. So you need to be humble. You need to tread very carefully when you're approaching these companies that are facing succession. And a piece of advice is, of course, not to call the company, go there and ask if they want to sell and throw up the big money bags on the table, because this is not the most important thing when it comes to what they want to achieve. They want their baby to live on a prosperous, nice life going forward. So a better way is to contact companies, speak about potential partnerships, initiate some dialogue about taking the company into the future, build a relationship, and of course to let the process take the time that's needed. So I think that's one very important aspect when speaking to a Polish company. Be humble when you're approaching them. We have a quite diverse audience here today, so representing many different sectors. We know that we have many M&A experts and specialists. There are also companies who are using M&A as a vehicle for international expansion or to develop their supply chains. Nevertheless, I'm going to try to touch on some of the top opportunities that are out there. And if you look at historical transaction volumes over the past 10 years, it's a quite broad range of industries that are covered. So there are opportunities available in many different sectors. However, some of the top sectors, both in Polish economy and in terms of traditional or historic transaction volumes, are still very interesting. And those are maybe some of the more obvious ones and some more innovative and growing sectors. The service sectors or non-industrial services, which is quite broad field, but that presents really good opportunities. The service sector contributes to a large share of the Polish economy and the Polish growth. Really strong human capital in Poland, so that's a driver of lots of transaction volume there. On the industrial side, the manufacturing sector is the backbone of the Polish economy, accounting for about a quarter of Polish GDP, and they're with really strong manufacturing traditions all over Poland, in most parts of Poland. So that's somewhere where you can find really good opportunities as well. The software sector, lots of really good IT people in Poland, developers and other professions. And the IT sector is growing, and we already heard that before, that IT and software is an area which is very interesting in terms of M&A. And then lastly, and we also had, that's quite interesting to know that we have lots of great software development companies within the chamber as well. So that's in this room. I know we have a lot of IT people, so that's a great way to network within the chamber. Another area is the energy sector, which is developing really well, and where there's lots of interesting things gonna happen over the coming years. There we also have a chamber activity coming up in, I think it's on March 22nd, which is going to be a sharing of best practices within the energy field and in terms of sustainability and efficiency. So that can be recommended as well as a chamber activity. And then there are many other sectors which are interesting: healthcare, medical devices, Packaging is something where we're seeing lots of activity lately, and which is interesting going forward. This is not purely M&A, but in terms of both M&A and investments, there are really good opportunities in the tech sector in Poland. Poland has a vibrant startup scene. And right now, there are some, I would almost call it outstanding and or extraordinary investment opportunities in the sector. Some of those things that are happening through this entity or this organization called PFR. It's the Polish Development Fund, which through their one of their areas, which is called PFR Ventures, they have created investment vehicles in a VC setup where they co-finance VC investments. And this creates right now a few quite interesting opportunities. First of all, we have an investment period that is just concluded by last year, where different stage of growth stage companies have been invested in. And now they are into a phase where they need to be divested because they have an investment period of 4 to 6 years. That means that lots of quite fantastic companies are getting out on the market in a market environment where there's a lack of financing right now. So it's an opportunity to either invest in those companies in the next round or to acquire technology if it's something that's suitable for your portfolio. So there are going to be divestments in these companies until 2026, 2027. There's going to be a new investment period starting probably towards the end of this year. It's a little bit postponed versus the initial plan. That's also a good opportunity to invest. But what might be even more interesting is the gap that's created between these two investment periods, where one of the vice presidents of the board expects the first half of 2024 and probably all of this year to be a difficult period for the Polish market due to a lack of financing for small growth companies, and so that might create a quite interesting opportunities for everybody in the tech field. All right, so last but not least, today is a very special day for all of us. It's Fetisdagen, the Fat Tuesday in Sweden, where we eat a lot of semlor. I'm not going to make any poll how many you have eaten today already. But in Poland, there's an equivalent. It's called the Fat Thursday, which happened last week, where we eat lots of pączki, donuts. So if you like semlor, make sure to pick up some pączki next time you're in Poland and try them out, even though Fat Thursday was last week. You can still get them out there. And if you happen to be in the bakery industry, why not look into acquiring maybe a pączki bakery in Poland as your next international expansion opportunity? So that's all for me. So if you want to speak more about M&A in terms of maybe expanding your market channels, developing your supply chains, or finding strategic acquisition, feel free to reach out. I'm gonna be outside after the seminar. We're gonna have some networking. There's some, not maybe semlor, but some other delights, sweet delights in the corner here that you can enjoy as well. So I'm looking forward to speak more afterwards, and otherwise you can find me online as well and connect there. Thanks a lot and good luck out there.
For your presentation, a lot of to digest, I think, a lot of opportunities. And now we have the last presentation, and it will be quite a journey. The last speaker will take us for a journey, quite a journey from 0 to 2 billion SEK in 2 years. So I would like to welcome Sebastian Karlsson, CEO of Lyvia Group, to take it to this journey.
Thank you.
The floor is yours.
Perfect. So thank you for that. Nice to be here. Special thanks to Jerry, who initiated the contact, and also Jakob for inviting us to this event. I will also try to have the correct slide there. I'm not Fredrik. even if his insights was really, really smart. So my name is Sebastian Karlsson. I'm the CEO and co-founder of Lyvia Group. If you want to add me or get in contact, just add me at Sebastian Karlsson at LinkedIn and write in the topic that you were at this event so we can get in contact. Because we think that that Poland is a really attractive market. That was actually the third market outside of the Nordics. Spain was the first, and Poland was number two. And also I have my MD of Poland here, Sasha, who's also in the back there, always trying to get away from the teacher. So I will just talk a little bit of what we are doing. So we have a lot of graphics here because of our CMO here. Here is some bragging numbers. Anders, you said we're not going to brag, but let's do it anyway. Today we have 41 portfolio companies. We talk a lot about M&A, but I'm actually also into Fredrik's point there. We see ourselves as allocating capital, not only doing M&A. So if we find that it's a better business rationale to do it through organic growth, if the customer acquisition cost towards lifetime value and the total addressable market is there, we will also have that into the mix of growing. But of course, when you grow in the beginning, then you need to use acquisition as a tool to be able to have the vehicles to grow them organically afterwards. We have a revenue of plus 2 billion. Today we have actually 1,500 employees all over Europe. We're focusing on business critical software, business critical third-party software, which we resell. I will go into that a little bit later. And also team delivery of developers that are developing business critical software for our company. So business critical and software, that's a key component for Lyvia. Here is actually, we're trying to explain our business model in an easy way. And here you can see that a lot of the core enterprise software systems like ERP, CRM, BI, cybersecurity application, it's often hard for us to own that type of companies because it's really, really expensive. So the returns for our stakeholder or shareholder in this case is not acceptable. So instead we distribute those type of softwares. What we can own is more of the niche software, and that could be add-ons to our ERP system, for example, a facility management system. It could be an add-on or a module to a CRM or something like that. And at the upper circle here, we also have expert services. So developers often working in teams, like the companies that we own in Poland, actually, which deliver business critical software to their end customers. And if I could just choose a little bit and made some requests to some of the developers here, is that you're really good in Poland of delivering IP outside of Poland, but I don't see as many own software company in Poland. So that is something that I would be happy to collaborate around a little bit. You probably maybe show me wrong later on, Fredrik, and I'm glad to do that. Here is our journey, and as you can see, we have HQ here in Stockholm. We have 65% of the revenue still coming from Sweden, but we were quite fast in moving outside of the Nordics. We choose Spain as the first country, and that was maybe I will say because the competition wasn't that big in Spain, especially when you come down to the companies that we acquire. We acquire companies between 1 million to 3 million euro in EBITDA. So I won't say that we are alone, but it's a little bit too small companies for the PE funds to acquire them, but it's a perfect match for our side. And then Poland was the second country, and I think Sasha will talk a little bit about how Poland are afterwards. But I agree what Fredrik said, and also some of the other speakers, that this is their baby, the Great Succession. I actually stole that one, already taken in as my own. But it is exactly like that, and we can see that culture because it is the first generation that actually have the possibility to also do the entrepreneurial journey. So you need to be cautious when you approach a company in Poland, and that's why it could be good to use someone like Carlsquare So free speech there for you. Then we also have companies in Holland, and the last 2 acquisition was in Holland from our side. And then we also have 1 company outside of London in Brighton, actually. So where we are growing right now is in everything outside of the Nordics. A lot of people working with acquisitions here know that the competition, when you compare to GDP, is much higher in the Nordics than outside of the Nordics. So I think this is a great opportunity for more people to actually visit some other countries. And you also see the journey that we are on. We are using, like I said, acquisition as a tool for growth. We had a really hectic 2022 with 20 acquisitions. We've done 10 during last year, and now we have finalized the first one, and more to come. But we did actually do some acquisition, both in 2022, 2023, and 2024. And if we would do the data from your slide, that 98 acquisition from Swedish company, and we take them into Fredrik's pie chart of the amount in software, I think actually we stand for at least 15 to 20% of the acquisition in the sector for IT. And we're always on the lookout for more. We will talk about later on, because I think also what people are mentioning here today is I think it should be a game about capital allocation, not only acquisitions. I think often the market and all the different companies, they become a one-trick pony quite fast. What is the trend out there? And right now everyone is talking about acquisitions, even more maybe in 2021, 2022, when it was clown world out there. But now people are looking more at the business rational, and that's exactly what we are trying to do. So here is our team. We are divided into 2 units here, or business area. The ones who is responsible for all the acquisition over Europe, and the ones responsible for all the organic growth. And we should always choose where we allocate the over liquidity that we're creating all the different legal entities that we have. And it could be a sales and marketing initiative where we see that the returns is much higher than it is if we actually send it up to HQ and do an acquisition. And like I said, I think also the opportunity for a market as Poland, that is so much larger than I think sometimes Sweden understands, also has a great opportunity to grow and distribute software or other products organically. I'm not going to talk against Carlsquare, but we work in a little bit different way. We don't work that much with brokers. I think sometimes it's good with advisors, even if you do both buy side and sell side. But we try, as you saw on the earlier slide, we're trying to do all of the origination ourselves. So we put a little bit, I would say, more money than maybe our peers into building our own M&A team, and we try to do everything ourselves, because we're talking about sustainable M&A. I think that was the headline. And what is sustainable? Sustainable for us is, of course, having a good capital structure for the shareholders. That is important. But it's also to be sustainable, you also need to have some time with an entrepreneur, because it is their baby. So we can actually structure the bid, for example, in a good way. And also to be able to show respect for the culture. I think that slide was good that you show with a different culture there. And this is what we try to do. So we don't do much of structured processes. We go a lot with bilateral processes, because we need time and spend quite a lot of time with our potential acquisition. And it often end up with someone who's taking in an advisor in the later stage of the process, because it's better both for the entrepreneurs, but also for us. Because when you go into an LOI, the DD process, and then finally the SPA, of course, there is things that you need help with when you're doing an acquisition for the first time. I'm going to go through too much about this, but I also want to show something underneath the hood. What are we doing to get you some insights when we have the opportunity to talk? this is what we do. I know that it's easier to get access to the companies here in Sweden than it is in other countries. We have had troubles or a little bit of struggles in DACH before. I think Poland has been good, but I think that's maybe up to our excellent MD over there, who also happens to have studied in Poland for plus 10 years. So that could be something that is a success factor here. But here you can see just some of the processes when we work with M&A. It's actually more in depth if you will come in, and I will show you it and do a voiceover. But this is just to understand that we are working, even when we do an acquisition, as it were a sales process like anyone else, except really expensive salespeople. This is also a little bit about our owner strategy. I think there are different strategies. There are a lot of good companies who's doing more like passive management and putting everything out to the entrepreneur and just look through that they have the right entrepreneurs. We have chosen the path of being a little bit more invasive. For every growth director is responsible for 8 companies. You saw the guys and girls at the bottom there on the last or 2 slides ago. They are the one who is actually responsible for continuous the 5 to 10% organic growth, but they're also responsible to sending insights to the M&A team that we work with. So they understand, okay, here we have an add-on acquisition. No, we shouldn't actually use this over liquidity at HQ for a strategic acquisition in Spain. We should use it here because the opportunity is here organically. We try to have deep industry knowledge around IT. So we were focusing of hiring growth directors who actually are coming from the IT sector. Of course, we want to continue the companies to grow, and I think sometimes that's an I would say a bottleneck when we take over, because the entrepreneur has been really good at driving the company to a specific place or a plateau, and then they have problems really getting out the correct KPIs to understand and also allocate what we're talking about, the over liquidity that they're creating. And I also I would have done that if I was an entrepreneur, because it's dividend and I can I buy that sauna or extra boat or something like that. And then we work quite a lot with networking. We're doing a lot of tenders joint. There is a lot of a Polish company now that we have acquired who's doing business here in Sweden. And of course, it's a good arbitrage opportunity for us because they are a little bit cheaper, but they are, I would say, often much better also than they are in Sweden. So the developers in Poland, they are definitely world class. The only boring part is that I'm always saying to the entrepreneurs, you need to do IFRS, you need to do the financial reporting. That will sometimes kill you, but you just need to take that into consideration when you do the choice. And this is also something that we're trying to create the entrepreneurial journey for Lyvia. I know I'm coming more from the operational part, like you, Fredrik. I'm not an M&A professional from the beginning. And I think it's important when we take over their baby and their heritage, it's also important that they feel part of our family. So we're trying to put a lot of effort into let our entrepreneurs join our journey and also be part of growing inside Lyvia. So here you can see the different components that we work with, the further on the right that you are coming. So actually one of the first acquisitions that we did in Sweden, the first founders, so the first generation founders, there were 2. They have actually gone all the way now to being investor, and I think soon they will also be handing out their Wall of Fame ticket and also free coffee at the HQ for the rest of their lifetime. So I think that was that. Sasha, do you want to say something about what you see, because you have worked both here in Sweden with acquisition and you live here in Sweden, but you go down half of the time?
differences. Something that Fredrik mentioned there, the hunger from Polish side, as we saw in the picture from Piotr, I believe, after Second World War, Poland was destroyed. Then there was Soviet Union. So there is just a new generation of wealth creation, basically, which was not how it was in Sweden, which successfully omitted the war. So people there, and it's not only entrepreneurs, their hunger for achievements. It's people, developers. That's why they're able to develop so quickly as the fastest growing economy of EU for the last 20 years. So there are definitely opportunities, and it is cheaper a little bit if you're talking about M&A than compared to Western countries.
Thank you for that, and I can also, before we end here, I also agree with Sasha. When we go down and do our trips or road shows, the entrepreneurs and the level of entrepreneurs, it's ridiculous. I think they are maybe the best in the group, also together with the Spanish ones, because they're also really hungry for success, and yeah, I agree. So thank you very much. We're here, and like I said, you can just add us on LinkedIn and we can continue this dialogue. Thank you.
I'm really delighted that we concluded the presentation part with such a smashing success as you are, which is a very positive note. And on that positive note, we are now moving to the panel discussion part of our event. So I would like to welcome here to the stage to join us Elisabeth Forslin, Adriana Krzymowska Larsson, Michel Eriksson. Please join us. Bartosz Pastuszka, Oleksandr Fomenko. So I guess, Oleksandr, you may be going back here. Christopher Dughieri and Adriana Ziecik. Well, a little bit squeezed, but I'm sure it will be fine. So we've heard a lot about successes, well, also a bit about possible difficulties. So now each of you will have a chance to have a take on this. You know, is there a secret to successes in M&A? How to avoid failures? And Elisabeth Forslin, I would like to start with you. The floor is yours.
Thank you. Very nice to be here. So I think when it comes to M&A, everyone has to realize that it's quite a hard work. You know, everyone thinks it's a bit fancy to work with M&A and you're making deals, but it's really hard work from the day one to the end. So I would say stay true to your strategy. That's really important. What you pointed out, that do the work beforehand so you know why you want to do acquisition and have the strategic rationale clear for you, because that's where it all begins. And then I would also emphasize culture, the culture fit, as you know. And also during the M&A process, you have different phases. You compared it a lot to a marriage, and it's a bit of a relationship. When you first meet, it's really lovely. And then you go through the due diligence process, which can be quite challenging sometimes, especially in the end. And there you can really see how people react. And if you work well together during the hard phases, then you will work together during the hard phases also after the acquisitions. So you also need to dare to step away, I think. That's really hard, because I've been in a few processes where you really ask yourself the question, will I be able to work with this person after the acquisition? And in those two cases, it's really turned into problems afterwards. So really challenge the culture fit and the personal chemistry during the process. And then, of course, it's always about communication.
Yes, and I think that the communication and culture is coming back and forth across all the presentations. I think something that is really, but now we also have hard work, which is not to be underestimated.
And also get the internal team to realize, because as I said, everyone wants to be involved in M&A and they think it's quite fun, but it's hard work and they have their daily work also. You know, if they are in the finance department, HR department, and then they need to take on the acquisition, both the due diligence work and also the integration on top of that. And that can be challenging. So
a lot of challenges. So Adriana, what would be your take on our topic?
Okay, I'm not the first lawyer on stage, so most of my ideas have already been spoken, and I don't think there's a lot of controversy in saying that you need to be prepared and so forth. My background is that both my parents worked as advisors in M&A, more on the brokerage side, and I have a law degree and a doctorate in tax law from Stockholm University. So for the last 15 years or so, since 2010, I've been working on a law firm with two of my sisters and one of my brother. What we do is mostly M&A and dispute resolution and some mergers and some real estate. So I think my advice that will come more in the form of a story. My dad says that the first acquisition I worked on was when I was 4 years old. He says that my preschool was closed for that day, so he had to bring me on a negotiation. And the thing is that at that day, at the stage in that deal, was starting to fall apart. The buyer had started to be a little bit have a bit of an aggressive rhetoric towards the seller, and the seller had started to mimic that, and they were getting further and further, of course, and it seemed like there would be no deal. So they planned a final negotiating meeting where they would all sit down at the table and try our last effort to fix it. And I showed up at that meeting, a 4-year-old girl sitting there listening and watching everyone as they spoke. So what that did was that people started to adopt a more calm tone and started to try to keep in mind that it's a child is sitting at this table and listening to what we're saying. And after a couple of hours went by and some more time went by, and it actually started to make some process and progress. And after 6.5 hours, they finally agreed to a final agreement. So still to this day, I don't know if my preschool was actually closed that day or if my dad took me there on purpose. But my advice is that you need advisors who understand what each situation needs. You need an advisor that can say that in this situation, we need someone to calm down this negotiation so that we can actually reach a finishing point. Thank you.
Thank you for sharing the story with us. I think you should have, your father should have charged for your work.
I know it was child labor.
Well, still. So now I would like to ask Michel Eriksson to share his take with us.
Yes. Yeah.
Have you also started at 4?
No, I did not. I did not. My name is Michel Eriksson. I'm partner at EY, M&A partner at EY in Stockholm here, based Stockholm. And my perspective is I'm working on sell side, private M&A sell side, industrial companies, business services. And yeah, what is important? One thing is like price expectation. Normally, sellers want more than buyers want to pay. That's sort of, it comes with the territory. So then how do you bridge that? I think a good starting point is that when we take on a mandate, we need to ensure that we are somehow aligned with the seller or vendor in terms of price expectation. Of course, as a broker, or you have to be a little bit, you cannot be too shy, but at the same time, you don't want to go out there and try to sell something a price you can't get. So that's one thing. The second thing, I think, in terms of negotiation, which I think is very important, is that you need to build trust, because trust is so important. Trust between buyer and seller, because if there's no trust, then it's going to be a problem. So I think those are key things. And then also when you sell a company or buy a company, you want to have positive surprises, not negative surprises. So negative surprises can kill deals. Negative trading can kill deals. So there are a number of things. And it's also also, as you said, you know, the lawyers, I mean, sometimes it feels like when we work on transaction, the lawyers, they come in, the diligence people come in, they just want to kill the deal. I'm the only one working for the deal. Sometimes, but so I think that is sort of a couple of takeaways here. But I think the and one important thing then again is that also going back to when you prepare the company for a deal, or when you buy a deal, you have to do your diligence, you have to prepare for everything and so on. So in a nutshell.
Thank you for sharing your insights with us. And now, can you pass the microphone to your neighbor? So, Bartosz Pastuszka.
Good afternoon to all. My name is Bartosz. Yes, good afternoon. My name is Bartosz Pastuszka. It is a pleasure to be here. Thank you, Jerzy, for invitation. My experience becomes because 10 years ago, I sold my first company to Swedish companies Securitas and Secredo. It was a successful deal. And what was the crucial point? It was that this transaction we made based on the natural trust and partnership, which we spent a lot of time cooperating together. And it was natural, we can say, situation which we decide, okay, let's go further. And all transaction was not, we can say, only planned for the, we can say, mathematical reason. All the time we're trying to find synergy. So in the, we can say, good transaction, 2 plus 2 is not 4. It's much more, and you have to, on the beginning, you know, create this synergy, preparing a good business plan. Another option, if you don't know your partner, is extremely precise due diligence, but not only legal, not only financial due diligence. You need to precisely know who is your partner, because you have to know all details, what he, we can say, who is as a person. What was the first million which he earned? So you have to support some, we can say, risk advisors, which can prepare some kind of ethical due diligence or answer some kind of doubts which you have from the negotiation, because every, we can say, process of negotiation is trying to cover it sometimes. And to succeed, you have to avoid any risk situation or have a clear pictures, sometimes build it from the puzzles about the, we can say, about this business, and of course about the people which create this business. Still, Poland has a problems with corruption. Still, we have a problems with the, we can say, not efficient culture of the, we can say, avoiding frauds or trying to cheat in the, we can say, conflict situation. As we can say, Fredrik said, in Poland, it's a huge opportunity for the investment, especially we have a problem with succession. Our, we can say, economy starts 20 years ago. Now, these entrepreneurs are 60, 70 years old. They want to retire, but they send their children to schools in Sweden, in Germany, in United Kingdom, and they realize and become good doctors, good lawyers. They find a career in the, we can say, global companies, because they don't want to spend 20 hours daily in the job and get, we can say, couple heart attack developing this business. But medium-sized companies in Poland is a perfect target now. Another, we can say, we discuss why Polish capital and Polish entrepreneurs not coming to Sweden. I think this is this time will start, because we can say evaluation for the Polish entrepreneurs was, in my opinion, too high. But after, we can say, some economic situation, it will be time that it will be natural discussion. Sometimes from the, we can say, some subcontractors from Poland, it will be natural discussion, but based for the, we can say, this natural trust which we built from many years cooperating together, like in model for the presented from the Lyvia Group. So I feeling that this we can say opportunities in now, when the situation, even we can say geopolitical, is very difficult, will be very grown, because Poland will be perfect, we can say, target for the very effective middle-sized companies. And also Poland will be natural platform when the development of Ukraine will happen. So I think this is a good time for the, we can say, strategical move. But please remember, we are in a little different cultural level. Still corruption, still risk problems are very, we can say, natural. especially to avoid, we can say, disputes, because we say disputes in court in Poland is almost, 3-5 years, sometimes. Now we can say reasons of reputation, some reasons of the confidential matter are sometimes more value than sometimes value of the transaction. So it's important to know each other, and we can say this process of preparation, be very diligent on the end.
Thank you for your insights. And now, Oleksandr Fomenko, you talked a little bit already, but please share your thoughts and views with us.
Yes. First of all, once again, thank you for the invitation. A little bit of formal presentation of mine. I am a managing director at Lyvia Group for Central Eastern European region. My background, I'm coming from Ukraine, after which I lived and worked in Poland for almost 10 years, after what I moved to Sweden. So I have a little bit of understanding of differences, maybe like Conrad, who moved other way around, of how these two countries, work together. And I've been in Lyvia for 2 years, since the time we acquired 3 companies in Poland. So what we learned from these cross-border deals is, there is a foundation which needs to be ticked off, which is strategic objectives. And this goes both for buyer and the seller. So from buyer, like what sector are you looking at, what size of the companies you are looking at, and why do we want to acquire companies? Is it just to acquire client base or get access to new region? Or maybe you're building something bigger where you want separate companies to prosper. From the seller's perspective, it's also, are you just looking for an exit? Are you just looking for a bag and money and forget about it? Then perhaps you go to a broker or some PE fund who will resell and do it over and over again with your company. Or maybe you want you have some expansion plans, but by joining a strategic player, and in this way you are accepting that, okay, you will get a share of bigger market, but then you will probably become a regional manager. So you will not be managing your own business, but it will be some directions coming from the top. Or again, you may choose more of autonomic acquisition, you can say, where you remain the head of your company as part of bigger umbrella. And then, on all this process, there were a lot of smart thoughts said today. What I want to concentrate on is, again, transparency and communication. This is something, there are so many things which can go wrong during an acquisition process. And typically it's long transactions. It's a lot of negotiations, half a year, maybe longer, depends. So you need to be transparent in expectations of what are you looking for, what kind of valuation you are looking for, but also what are you expecting post-merger from both sides. In terms of cultural aspect, as Jorge said today, which is true, that Polish people often they expect that someone is trying to lie to them or win something unfaithfully. While Swedish people, they tend to leave their bicycles on the street and not locked. This is just the difference. I'm not saying that something is better or right, but this is just the differences. And when working with Polish and Swedish legal teams, this is especially visible. So be transparent, communicate all the potential challenges and issues beforehand. As an example, the 2022 war happened, and just before that, money were free. Banks were just, please take my money and invest it. After that, suddenly, bam, liquidity crisis. All of this affects successful deals. I think my time is.
Yes, thank you. Thank you. And now, Christopher Dughieri, can you please world?
Yeah, I come from tech side. Hi, everyone. I'm Christopher Dughieri, representative of Software Mind here. And I just want to reminisce. I was 22 years old working on a floor. And then suddenly my manager told me, you need to connect these offices on the system side. And I started connecting them, and I realized there were 2 different companies merging. And I had to do the integration of work on the floor. And I heard everywhere I went, to every office, they were always talking about the other ones. The other ones don't know how to do this for real. And I thought that was really interesting because I liked both parties, and I didn't see that. But there was a lot of confusion about the culture and the dialogue and the communication, because there was basically I would say, uncommunicated idea of what was to be achieved, or the vision. So that was at 22 years old. When I was a bit older, I think I was 30 something, my manager came and told me, we're at stage 6, which Conrad had on. Now you do the integration. I said, of what? Well, we bought the company. So you just integrate all this. And I was, I think, CIO at the time and everything. I wasn't a part of the planning. I didn't know what was expected to be achieved. And that was also really hard to achieve something at that time. So coming back to the get your idea straight from the beginning, communicate it to a wider team, and also to the both entities trying to do this integration work, if you're trying to do that. Anyhow, put your vision outside there. And later on, I was on again on the buyer side and on the seller side. So I've seen a lot of these parts. And regarding tech in this perspective, you tend to see tech as something, you know, it's 1 or 0, it's black or white or everything. But today it's enabling most businesses. So you should really put the tech in the perspective of the people and the organization. And if you do these different DD tracks, you look at IT, you look at legal, blah, blah, blah. But it's so important to have the holistic perspective and also see tech as a part of everything, and how you get the people to integrate the tech and the business, because probably your product or service is tech enabled. So there is a lot to do. And if you look at tech at this kind of separate part, you will never create those integrated products, never create those integrated services, because it's very much harder than you think. Some perspectives on this.
Thank you very much for this. And we are coming back again, even if it may sound surprising for many of people present here that someone from the tech side will talk about more of a soft things. But now we have Adriana, who I don't think that something that you will talk about was actually mentioned at all before today. So.
Adriana Ziecik. I'm a founder of IP KIOSK Intellectual Property Concepts. I'm yet another lawyer here, but I deal exclusively with intellectual property. And IP rights are really significant. It depends, of course, on the transaction. If the companies are similar, the IP rights may be crown jewel for the buyer. Sometimes it might be only a bonus because it is not the core business. But as a matter of fact, they are really significant. And what is really, really important, and what is secret behind, is to have your IP rights in order. It is really important for the buyer who knows what he really buys, and it's really important for the seller who may be free from any liability later on. What is important is to know what is protected, whether I have some patent, it is a design, is it trademark, is it only trade secret or know-how, and I can license this. It's really important to know what. It is also important to know where, because all these IP rights are territorial. So on which territory my right is protected. And the third issue, which is really important, especially in M&A transactions, is who is the owner? Because very often, especially in capital groups, it is that is only one company which has all the trademarks and license that to the other companies in the group. And at the end of the day, it may turn out that, no, it was not that company I bought. I don't have any trademarks. I don't have any designs. I don't have any patents. So this is really something. It is also connected with right IP portfolio management. Because it is not only that once I registered and that's okay. No, in case of trademarks, it's quite easy because the renewals are every 10 years. But for instance, in case of patents, there are annuities. Annuities, it means it should be paid every year. Yeah, it might be very strange for you, but it really happens that the wrong IP portfolio management leads to the situation that we are just losing. and there are the deadlines to pay the annuities, to pay the renewals. In some jurisdictions, it is some grace period of, let's say, 6 months, but later on it is not extendable. So it's really, really important to remember about it. What is also remember in M&A is that it is not enough to say in an agreement that all the assets. No, each IP right must be clearly indicated in the agreement, either in the agreement or in any appendix. But it might be application number or registration number, depending. But it is not enough just to say the general, all my assets or your assets, but it must be stated clearly. And maybe last remark is that it is also important to reveal it in the registry, so the public may know who is the real owner, applicant or the owner of a given right. So yeah, it seems that IP is a niche, but it's really, really wide niche, and I think it's of importance also in M&A contracts and agreements. Thank you.
Thank you very much. Adds yet another dimension to our discussions today. So I'm very, very happy you mentioned it. So it was the last panelist, and I think we are moving now to the Q&A part. And to start with, I actually have one question that I would like to direct to Adriana Krzymowska Larsson. Earlier today, we heard a lot about opportunities unrealized, mostly between Sweden and Poland when it comes to acquisitions. So if you were asked by a Swedish company, you know, what to really take into account while moving to Poland buying companies, what would be your take on this?
Thank you. I would probably not be the perfect person to ask this, actually. It would be more the other way around. If a Polish company wants to start or acquisition something here in Sweden, I would be better prepared to answer that question. I am Polish, but I am born and raised here in Sweden. So I've lived my entire life here in Sweden, and I practice law here in Sweden. So I think if I allow myself to change the question, I think that what a lot of Polish companies need to understand when they come here to Sweden is that there is a culture of transparency in a way that is not common in the rest of Europe. It's more Scandinavian, and I think it's more extreme in Sweden, even in Scandinavian measures. But that only goes to a certain extent. Like you have to be invited into a certain room to be allowed to get the full transparency. It's not as open, and Swedes aren't as blue-eyed as the rumor has it. It takes a while to get to know a Swede. It takes a while to be let into a conversation and to be part of it. And it's not until then that you actually can understand what they want and how they think and operate. So I think that's a big cultural difference. And one more thing is that in Sweden we have we're sticklers for rules. If something is a real, we can't really negotiate. If there's a statute that says something has to be done. In Poland, I think you have a more of a softer approach, that a problem can be fixed. We can work around it, and in some way it can be fixed. But Swedes are a little bit more rigid in that sense, that if it says no, then it's a no, and we have to think of another path.
Thank you for this. I think we are coming back again to cultural differences and clear communication, which I think is important no matter where we go. So, are there any questions from the room?
I can start. It's not a question, but more of a comment about the cultural differences between Sweden and Poland. A telephone call I call somebody in Sweden and they answer Andersson. if I call to Poland, słucham, which means I'm listening. Can I speak to Andrei Kowalski? And they said, who is asking? So I mean that explained the difference in openness and culture difference a little bit.
Thank you very much. So, any further questions?
Thank you very much. Are there any differences in culture between the cities, the bigger cities in Poland, would you say, in culture, or no, like if you take Germany, for example, it's huge differences between the cities?
I mean, definitely we can draw a line in terms of well, business, which is situated in the particular regions of Poland. So south being heavy industry and maybe mining, while southwest would be IT, and Warsaw similar finance IT. So in this sense, you can perhaps break down. It will be very rough breakdown. I don't want to say that that's the only thing, but when you're looking on the industry, software, it will be more. Well, new capital, you can say, new brains, people with new ideas, by just being younger. It's nothing wrong with having classical ideas, while more traditional industries, typically people will be older there with old ways of doing things, and again, nothing is wrong in it, but this is the differences which I noticed in my career.
Thank you. So I'm wondering, to those of you who are actually working with acquiring companies here, and I think that might be Sasha. Is it Sasha or Alexander? Sasha. Okay, thank you. And perhaps a few others of you. Could you please give me one concrete example of something during an acquisition process where you encountered an obstacle that was quite concrete and how you overcame it?
Well, I guess no one wants to start. Obstacles. Yes, I mean, I never came to that conclusion yet, and I don't have a 4-year-old at my reach yet, but it's definitely something which may be considered in the future. In terms of obstacles, again, probably it's expectations versus communication. So if both parties were communicating their expectations beforehand, and well, some bridges were built to agree on these expectations, then typically problems don't arise. But again, it's a very complex process. So no, I will not have a clear answer of avoiding them, but this is something which I feel is important to talk first and then do.
We have Christopher.
Yeah, thanks. I just want to add to that. I experienced one time ending up in a situation where I was recruited to a company who had bought another company, and they said we aren't getting the effect we wanted. They had an idea, but the idea wasn't really, how should I say, really worked with. It was kind of visional, but they didn't try it. So we had to tackle that to kind of restart. What is the idea that we wanted to achieve? What's the value? So we had to do a lot of work with the product portfolio, the go-to-market strategy and everything. And the second time, a couple of years later, when we wanted to buy another company in that same sector, we did our homework on stage one, as Conrad said. So, and also in the integrational work, we worked a lot with communication and getting that vision out in the company we acquired, what we were trying to achieve, because then you can have a choice. I want to be a part of this journey. I like it, even if maybe the software you have developed for 10 years is about to be sunset. If you can explain why and what you want to achieve instead, people can make a choice to say, I want to be part of this, and that can happen in a good way. So that's an example.
So, if we may pass to Anders Elgemyr.
Flip in that advisor, and I think that you have the same experience. Every deal, you have at least one time when you get lost in the ditch. Every deal, you feel that this is not going to work. So one solution is, and we touched upon this before, is to have the principles. You can go around, so you can start with advisors, and then you don't find a solution. You can go to the lawyers, you don't find a solution, then you can go to the principals, and then have a solution. So you need to have the understanding. Every deal has its complications. Every deal will be some time in the, like, it's a fuck up, sort of.
Yeah, and I think I can only mirror that. I mean, in every private deal I've been working on, there's always been like, you've always been in a situation where, will this happen or not happen? It's always like that. So because there's always be those very, very difficult obstacles you have to overcome. And I can only agree that I think it's so important that you get the right people in the right room. Yeah, but you have to time that. You don't have to overutilize that opportunity. But
yeah, and I can add to that as well that it's not always the senior people that normally, also if you work with entrepreneurs, they're a bit scared of people like me, come from the finance side, or the lawyers, they want to speak then to someone from the business side who they can rely on, and they speak the same language, so to say. So I would say to let the business people step in and take away the lawyers and the advisors could be also a solution.
I'd like to say a very simple, or it sounds very simple solution that I found that has helped us avoid a lot of problems in several different transactions is to employ a very detailed and specific schedule where every single detail has a deadline, because not only does that help everyone move forward to the common goal of actually closing the deal, but it also helps very much in noticing when something is off. When someone starts not to actually deliver on time, then that's a very clear signal that you're getting off course. You need to correct something.
One of the most exciting thing is price negotiations. If you don't have in the documents this so-called indicative price, that you know what the level is, then you can end up having been involved in discussions for about a month. And then you have this approach that the gentlemen don't talk money, the gentlemen have money. And then when it comes to the point that you need to say how much you are ready to pay, and then you would be met with the expectation, oh, that is not even in the close range of what I was expected. I remember specifically a deal when there was a Norwegian company and a Polish company, which is located in Bochnia, but the client pronounced that Bosnia, so I was expected that we were going down to the Balkan states, but when it went down to Bochnia, and we were discussing back and forth, and everything was done perfectly well, and then we came to the conclusion, okay, let's talk price. So it turned out that the Norwegians were ready to pay for a little Volvo, and they were expecting a Maybach at least. So we were like light years from each other. And the only happy part was lawyers, because we get paid no matter what. But the parties went home and were equally unhappy. So this is something that, unless you have in the structure from the beginning that you are forced to state indicative price level, then I would advise you to start with the indication of the price at a very initial stage, so you don't lose money and waste money on discussing things that will prove to be good for nothing. Maybe one more thing, it's on different level, in comment to Adriana, Adriana Krzymowska, not the other Adriana. We have two Adrianas. Would you say that Poles are more flexible when it comes to dealing with issues, whereas Swedes are sticklers to rules? That's true. But when it comes to legal side, so Polish legislation is much more work through. So there is detailed down to any single thing, whereas Swedish legislation is a little bit on a higher level. Well, whatever is not forbidden, it works. So I give you one example. Previously in Poland, we have the situation, you have a board and you have 3 board members, but none of them is able to and the signing forces together. So there's the situation that those 2 could not give power of attorney to the other one because that's contradictory to Polish doctrine. This is not in line with law. Whereas the Swedish lawyer would reason, well, I can give to Kalle, who's sitting on the park bench and drinking beer, and in what way that would be legality. So in what way is Kalle better than the other guy? So there are also parts that Swedes are more flexible than we are in Poland. But I agree with you that when it comes to solving crisis, Poles are definitely much more flexible. I like that word because it's not bending the law, but you are flexible on interpreting it. So, thank you.
Here we have a question. There we go.
Hi, my name is Rafał. I have a question because I recall that someone of you said that save the top executives for the final discussion. Negotiating. If something gets wrong, you can always blame the lower people to do that. But I'm just thinking of the credibility. I learned from being a representative for a North American company that you always should ask for, do you have the budget? And as you mentioned, what is the frame of the value of what we're discussing? Are the people in the room here to make the decision? And now if we don't put out the top executives, would it be trustworthy enough?
If you remember my schedule of how an M&A deal goes on, so executives comes in number 5, where it's signing and closing, and champagne is being brought forward. So that's where the executives, the big top guys, come into the pictures and take all the glamour. Whereas the other guys who are on a negotiations side, as I said, of course, it's when we're talking to a middle-sized businesses or small businesses, there is one top guy and there is nothing else. But when you talk listed company or bigger companies, so there is certain levels of various levels of executive involvement. So I would say that the top guy wouldn't be involved on the negotiation side because when something goes wrong and you go in a locked situation, so either is a deal breaker and you cannot move on because there is no one else to take over and override this dispute. And if you don't have this top guy involved, then you call the top guy and say what one situation you ended up with, and he will enter this stage and with his unlimited wisdom solve the problem, and we move on.
Thank you. So we have one more question.
Just a small little question about family companies. There were 830,000 in Poland. Coming from a family company in the 7th generation now, I wonder what's the situation with the inheritance tax? We were freed from inheritance tax 15 years ago. I wonder what the situation is in Poland, because it can be a pressure on selling if the inheritance tax is a game changer.
So who would like to accept the challenge? Well,
I just do Swedish tax, sorry. But from...
Yeah, so here we have.
Hi, so I can say something about that because I met with my lawyer. Well, I turned 50, so I met with my lawyer. I'm the sole owner of the business, so I met to talk about how should I organize this, and I was informed. Well, I was asked, do I want to cut someone out in my family? And no. So he said, well, when you die, your wife has half and the kids get the other 2. It's just set by law. There's no like, you don't make a will. Like it's just set up in law. And so there was nothing for me to draft. I also learned that because I bought the business with the combined marital assets, we may say that actually I don't own 100% of the company. I own half. And it would be my half that would be determined in my death. Anyway, I didn't end up drafting a will because there was no need. That's Poland. Look, now the lawyer's like, wait a minute. Now, wait a minute.
There's a tweak to it.
Oh, good.
So my disclaimer is I'm not a tax lawyer and I'm not an inheritance lawyer, but it is true that there are default rules in law, but you can have a will and you can change it. So that's one thing. And in terms of inheritance tax itself, please don't treat this as legal advice because I just Googled it very quickly. So I would need to verify how accurate is that. But from what I see, as long as it's in the first line, so it's children inheriting after parents, I think there's a tax exemption. But maybe you have more accurate information.
They also inherit debt.
Yes, you also inherit debt. Yes.
They do, yeah. So I mean, again, I'm disclaimer, I'm not a tax lawyer, yeah, but have seen plenty of these kind of situations around transactions. So, if there's nothing in place, you're absolutely right. It goes through like the standard rules in the court system, and that's pretty disadvantageous to the person inheriting it or to the inheritor. So it is split according to certain rules, etc. You can have a will, and then that basically takes care of everything. Also in terms of having joint assets with your wife, so you can have let's say it's called rozdzielność majątkowa, so like a separation of assets within a marriage, so that also works. There is an inheritance, let's say, tax that gets applied. There are exceptions for let's say when it's going to the direct line. I think there may be some limits, however. But the way that most let's say transactions in Poland take place, these are not directly owned assets. They're actually going through a new implementation took place last year called Fundacje Rodzinne, so family foundations. And as long as the assets, say, remain within this foundation, then basically they are tax-free until those profits are distributed. And what we've seen in Poland actually has been many entrepreneurs setting up such foundations. These are highly beneficial from a tax perspective. We also saw some delays in planned processes because they were setting up these foundations. So and actually we see it as one of the triggers for increased potential activity coming down the line because it gets rid of a potential tax liability as well.
So thank you very much. And I think we are approaching the end of the official part of our event. Networking will come next. So thank you for all your presentations and insights. And now the floor is yours. So Dughieri.
So thank you. I am Vice Chairman of the Swedish-Polish Chamber of Commerce. My name is, in Swedish at least, Jerzy Ralowski. In Polish I say Jurek Rałowski, you can choose. So thank you very much to online viewers. We have no more for you, actually. We will now start the networking part, and I don't know if Dana is here, because Dana is the hero of the networking part, really. Is Dana here? Or has Dana left the room? Dana is the lady who has provided us with bakery products, the very best Polish sernik. I'm saying sernik, I'm not saying cheesecake, because I don't know, American cheesecake is very different from sernik. So if you want to taste the very best sernik in the world, and I challenge you to agree or disagree with me, please do. There is also orzechownik, which is a cake with nuts. It's not an accurate description, but the best I can do. And there are some Polish-style muffins. There is coffee over there, and I understand there is tea outside the room. So this is a very good basis for networking. So please start, making business with each other, and don't forget about the cookies. Thank you very much. And of course, thank you to all the wonderful speakers and the panelists. Thank you to Mats, who is doing the technical side. I remember that I am not allowed to call you a technician. I am supposed to say, you have to remind me. Digital facilitator. Mats is actually on the board of a Facilitator Nätverket, which is the Swedish organization association of digital facilitators. So congratulations. We have another board member over there as well. So it's a bit of a reunion of a board. Okay, thank you very much again.